Hi, this is David Myrland. Just a quick reminder, there are materials of mine at thebookpatch.com. I go to thebookpatch.com, click on bookstore and search, and my last name, search, Myrland, M-Y-R-L-A-N-D, brings you to a page with my publications on them. Hybertson versus United States, volumes 1 and 2. This is a publication I don't mention nearly enough. It's a book of citizens' initiatives, more than 100 of them in one place. There's almost, I think, a dozen proposed constitutional amendments, discussion about all of them. Just a wonderful idea, the citizens' initiative. There's a lot of problems you can take care of through the citizens' initiative. The left makes waste of everybody with a lot of their initiatives drives. Public vehicular travel. This is a brief and a criminal complaint about the fact it's racketeering. The Motor Vehicle Code's never been written to apply to anybody other than those using the highway as a place of business. It's a statutory analysis based on Washington State, but I suspect it's the same everywhere. The original motor vehicle codes were only written to apply to commerce, and they've never been broadened through an expression of legislative intent to embrace new objects within the scope of the law. Take from Caesar, volumes 1 and 2. Volume 1 is a complaint to Congress, January 1st of 06, to 80 members of Congress. Key issues about the tax code, especially, you watch my other videos here on YouTube, Key to the Code video, and the Section 83 tutorial, very big. And then there's the supplemental briefing of 014, several years later, 8 years later. Codebreaker, the Section 83 equation. I'm still the only one in the known universe teaching this application of tax code Section 83 to every paycheck. Everybody agrees it applies to all compensation, and they won't talk about it. They'll penalize you for asking in tax court. And currently, and it happens to be February 2nd, 2018, 2 or 3 people will be petitioning the Supreme Court with that involved very soon, right out of my office. The last one, 2 POTUS. This is a criminal complaint filed with the new president, Inauguration Day, about these very issues. And so peruse thebookpatch.com in their bookstore. Search for my last name, Myrland, M-Y-R-L-A-N-D. Now to our featured content. Thank you. Hello and welcome to yet again another installment of Codebreaker. My name is David Myrland. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis, believe it. And that's the reason for the punchline, which I will give you first. This is a precursory review because there's really not much to review in the memo. It's very straightforward. I haven't even read it yet, but only 4 pages, not a whole bunch of legal briefing or anything, but just a basic a list of these people did these things, and they did so to affect the president or the presidential candidate, Donald J. Trump. And it is egregious, no question, hands down, very easy to look at. Hard to accept, impossible to accept, but very easy to understand. And the punchline is first. Here's the punchline. Come on, punchline. You know? This thing won't even open. I was going to use this for the purposes of the presentation. Oh, can't be in full screen mode. Trey Gowdy's leaving Congress to, they didn't fill in that blank. They just said get back into the justice system. Jeff Sessions is a very nice man and a dedicated public servant. He does have the respect for the rule of law he professes to have. He does not think like a prosecutor. He is not a shark. And he is up to other people's gills in swamp scum. that he doesn't know how to address. And it is my prediction that Trey Gowdy's expertise and attitude, because he's far from retiring, the guy's really worked up. He's on a roll and soon to be on a mission, because I predict he will either replace Jeff Sessions when he drops out of Congress at the end of this term, or he will sign on to assist Jeff Sessions with what they have discovered to that point. So August would be the last time, maybe September, that he would have to act as a congressman, and then he could just switch over and change duties. And as soon as is lawful, become a Department of Justice official at some level, deputy assistant to the Department of whatever. And I don't think they're going to replace Jeff Sessions. I think they're going to use him right now for the investigations of crimes that will not have told the statute of limitations by the time Trey Gowdy can get busy. Between now and then, they can get a lot of sealed indictments, a lot of criminal complaints in place. People can plead guilty to criminal complaints. They don't have to get a grand jury indictment on every one. If they got enough goods on somebody, they can clean up. So it's a matter of resolve, and Jeff Sessions just doesn't think like a prosecutor. And we're looking at a federal felony statute. If two or more persons conspire to injure somebody in the exercise or free enjoyment of a right secured to him by the Constitution or laws of the United States, do you suppose the FISA law requires that they come to the court without fabricated evidence? That they come to the court honestly disclosing that, yeah, the DNC, Democratic National Committee, paid for this dossier, and those are material omissions that might rise to the level of material concealment, or a lie in the mirror. And if the people on the phone had a constitutional right to privacy, why would you say that? Well, they have to get a warrant to listen to you. I think that suggests pretty strongly you got a right against them listening to you, even under the FISA law, the Foreign International Surveillance Act, the Foreign Intelligence Surveillance Act, FISA. And under that act, they established this court and said you can review warrants in secret. And I'm sure part of the law was don't be a liar when you come to the court for a warrant. So if they had constitutional rights and a bunch of people put together that dossier and said, let's submit it as evidence that we should get a warrant, how is that not a conspiracy against the rights of the people on the phone? Whether they're campaign employees or official of the candidate Donald J. Trump or otherwise, do they have constitutional rights to privacy on those calls? You ask yourselves that. And if their position as a public servant compromises that to degrees, I'm sure there's case law on it. Go find it. And the reason I want to know if a felony's been committed, like that one, the one under 18 U.S.C. 241, they accidentally violate that all the time. And they intentionally violate it the rest of the time. Your rights just don't matter. And this campaign through this FISA warrant process is a great example of it. We don't care. We're going to go get that warrant with a fake dossier that has a bunch of salacious crap in it. But you have to sit back and go, what were they thinking? This is citizen's arrest of any felon, circuit by circuit. You'll see this reviewed slowly in the citizen's arrest tutorial here on YouTube. So I won't go through this slowly. Rather, I'll scroll through it And when I stop, you'll be able to pause the recording and read if you like. But this is citizen's arrest of a felon. Reasonable suspicion is a reasonable presumption that a crime has been, is being, or will be committed. It's different. It's less than probable cause. So, if I have reasonable suspicion to believe a felony is being committed, I have rights to a citizen's arrest. Check your state law, of course, and none of this is legal advice. So, citizen's arrest. As I scroll, you pause when you like. Pause. 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 Great. So appellate courts across the country, citizen's arrest of a felon. Yes, common law right, regulated or managed by state law. Here is the transmittal back to the House of Representatives by the White House counsel, Mr. McGahn, saying we've read the memo to Mr. Devin Nunes, chairman of the House Permanent Select Committee on Intelligence. And they're going to say, yes, we read the memo, make a couple points on what is and is not classified. We understand national security is of utmost concern. As I glanced through this letter, I did see that much, but I haven't read any of the 4-page memo yet. And we have here from the White House, Dear Mr. Chairman, on January 29, 2018, the House Permanent Select Committee voted to disclose publicly a memorandum containing classified information provided to the committee in connection with its oversight activities, hereinafter the memorandum. As provided by Clause 11G of Rule 10 of the House, the committee has forwarded this memorandum to the President based on its determination that the release of the memorandum would serve the public interest. The Constitution vests the President with the authority to protect national security interests from disclosure. As the Supreme Court has recognized, it is the President's responsibility to classify, declassify, and control access to information bearing our intelligence sources and methods and national defense. In order to facilitate appropriate congressional oversight, the executive branch may entrust classified information to the appropriate committees of Congress, as it has done in connection with the committee's oversight activities here. The executive branch does so on the assumption that the committee will responsibly protect such classified information consistent with the laws of the United States. The committee has now determined that the release of the memorandum would be appropriate. The executive branch, across administrations of both parties, has worked to accommodate congressional requests to declassify specific materials in the public interest. However, public release of classified information by a unilateral action of the legislative branch is extremely rare and raises significant separation of powers concerns. Accordingly, the committee's request to release the memorandum is interpreted as a request for declassification pursuant to the President's authority. The President understands that the protection of our national security represents his highest obligation. Accordingly, he has directed lawyers and national security staff to assess the declassification request consistent with established standards governing the handling of classified information, including those under Section 3.1d of Executive Order 13526. Those standards permit declassification when the public interest in disclosure outweighs any need to protect the information. The White House review process also included input from the Office of the Director of National Intelligence and the Department of Justice. Consistent with this review and these standards, the President has determined that declassification of the memorandum is appropriate. Based on this assessment and in light of the significant public interest in the memorandum, the President has authorized the declassification of the memorandum. To be clear, the memorandum reflects the judgments of its congressional authors. The President understands that oversight concerning matters related to the memorandum may be continuing. Though the circumstances leading to the declassification through this process are extraordinary, the executive branch stands ready to work with Congress to accommodate oversight requests consistent with applicable standards and processes, including the need to protect intelligence sources and methods. Sincerely, Donald McGahn, Counsel to the President. Do-da-day. Now, you're going to release this document, are you, lawmakers? It's kind of up to me, isn't it? Why don't I interpret this as simply your request that I declassify it for you? I like that. Now, and it went to Paul Ryan and ranking member of the committee, Adam Schiff. And so we get to the memo. Unclassified. Declassified by order of the President, February 2nd, 2018. Foreign Intelligence Surveillance Act abuses at the Department of Justice and the Federal Bureau of Investigation. This memorandum provides members an update on significant facts relating to the committee's ongoing investigation into the Department of Justice and Federal Bureau of Investigation and the use of the Foreign Intelligence Surveillance Act during the 2016 presidential election cycle. Our findings, which are detailed below: 1. Raise concerns with the legitimacy and legality of certain DOJ and FBI interactions with the FISA court, and 2, represent a troubling breakdown of legal processes established to protect the American people from abuses related to the FISA project. Those are rights secured to you under laws of the United States, aren't they? Conspiracy to violate those is 10 years in prison. Reasonable suspicion to believe they've done that means 300+ million people can arrest them anytime they want. Checkmate. See how I moved those pieces around the board? You ever seen that 4-move checkmate? 4 moves from the beginning when you're teaching somebody about chess? You can get away with that. First 5 times you try it. In the first maybe 40 or 50 games you try. And after that you won't get away with it. Where you just go 1, 2, 3 and you set them up for checkmate. Anyway, just 1, 2, 3. And their own actions have set them up for citizen's arrest, but it's a matter of putting the pieces in order, and bingo, suddenly they don't have a front door on their homes. Don't do that. Investigation update. On October 21st, 2016, DOJ and FBI sought and received a FISA probable cause order, which is higher than reasonable suspicion, authorizing electronic surveillance on Carter Page. Page is a U.S. citizen who served as a volunteer advisor to the Trump presidential campaign. Consistent with the requirements of FISA, the application had to be first certified by the director or deputy director of FBI. It then required the approval of the Attorney General, Deputy Attorney General, or the Senate-confirmed Assistant Attorney General for the National Security Division. The FBI and DOJ obtained 1 initial FISA warrant targeting Carter Page and 3 FISA renewals from the FISC. As required by statute, a FISA order on an American citizen must be renewed every 90 days, and each renewal requires a separate finding of probable cause. Then Director James Comey signed 3 FISA applications in question on behalf of the FBI, and Deputy Director Andrew McCabe signed one. Then DAG Sally Yates, that's what was DAG? FBI, FISC, oh my goodness. DAG, where are you? Here we are. Deputy Attorney General, thank you. Then DAG Sally Yates, then acting DAG Dana Buente, and DAG Rod Rosenstein each signed one or more FISA applications on behalf of the Department of Justice. Due to the sensitive nature of foreign intelligence activity, FISA submissions, including renewals, before the FISA court are classified. As such, the public's confidence in the integrity of the FISA process depends on the court's ability to hold the government to the highest standard, particularly as it relates to surveillance of American citizens. However, pardon me, the FISA court's rigor in protecting the rights of Americans, which is reinforced by 90-day renewals of surveillance orders, is necessarily dependent on the government's production to the court of all materials and relevant facts, such as the fact that Democratic National Committee paid for the dossier from Steele. It's something else. This should include information potentially favorable to the target of the FISA application that is known by the government, meaning exculpatory. If there's something that exists that erodes the probable cause they claim to have, they have to present it. In the case of Carter Page, the government had at least 4 independent opportunities before the court to accurately provide an accounting of the relevant facts. However, our findings indicate that, as described below, material and relevant information was omitted. 1. The dossier compiled by Christopher Steele on behalf of the DNC and the Hillary Clinton campaign formed an essential part of the Carter Page FISA application. Steele was a longtime FBI source who was paid over $160,000 by the DNC and Clinton campaign via the law firm Perkins Coie and research firm Fusion GPS to obtain derogatory information on Donald Trump's ties to Russia. How do you pay to obtain derogatory information? I thought you just paid to obtain information. Whether or not it was derogatory depended on the search. It's salacious in its motives to begin with. A. Neither the initial application in October of 2016 or any of the renewals disclose or reference the role of the DNC, the Clinton campaign, or any party campaign in funding Steele's efforts, even though the political origins of the Steele dossier were then known to senior DOJ and FBI officials. And B. The initial FISA application notes Steele was working for a named U.S. person, but does not name Fusion GPS and principal Glenn Simpson, who is paid by U.S. law firms Perkins Coie, representing the DNC, even though it was known by the DOJ at the time that political actors were involved with the Steele dossier. The application does not mention Steele was ultimately working on behalf of and paid by the DNC and Clinton campaign, or that the FBI had separately authorized payment to Steele for the same information. That's kind of relevant information. See, I told you this would be an easy document to absorb. There's not a whole bunch of law in it. There's not a whole lot of conceptual reflections or applications. It's straightforward that how come you didn't tell the court this? Number 2, the Carter Page FISA application, that's a Foreign Intelligence Surveillance Act application for a warrant, also cited extensively a separate September 23, 2016 Yahoo News article by Michael Isikoff, which focuses on Page's July 2016 trip to Moscow. This article does, they underlined this right here. This article does not corroborate the Steele dossier because it is derived from information leaked by Steele himself to Yahoo News. What's that called? Starts with fake and ends with news. The Page FISA application incorrectly assesses that Steele did not directly provide information to Yahoo News. Steele has admitted in British court filings that he met with Yahoo News and several other outlets in September of 2016 at the direction of Fusion GPS. In other words, they ordered him to go meet with others and leak a bunch of stuff, so a bunch of outlets started picking up this thread. Perkins Coie, the firm, was aware of Steele's initial media contacts because they hosted at least one meeting in Washington, D.C. in 2016 with Steele and Fusion GPS where this matter was discussed. A. Steele was suspended and then terminated as an FBI source for what the FBI defines as the most serious of violations, an unauthorized disclosure to the media of his relationship with the FBI, in an October 30, 2016 Mother Jones article by David Korn. Steele should have been terminated for his previous undisclosed contacts with Yahoo and other outlets in September before the Page application was submitted to the court in October, but Steele improperly concealed from and lied to the FBI about those contacts. B. Steele's numerous encounters with the media violated the cardinal rule of source handling, maintaining confidentiality, and demonstrated that Steele had become a less than reliable source for the FBI. Number 3, and remember we're covering 4 points. Excuse me. 3. Before and after Steele was terminated as a source, he maintained contact with the DOJ via then Associate Deputy Attorney General Bruce Orr, a senior DOJ official who worked closely with Deputy Attorney General Yates and later Rosenstein. Shortly after the election, the FBI began interviewing Orr, documenting his communications with Steele. For example, in September 2016, Steele admitted to Orr his feelings against then-candidate Trump when Steele said that he, quote, was desperate that Donald Trump not get elected and was passionate about him not being president, end quote. This clear evidence of Steele's bias was recorded by Orr at the time and subsequently in official FBI files, but not reflected in any of the Page FISA applications. A. During this same period, Orr's wife was employed by Fusion GPS to assist in the cultivation of opposition research on Trump. Wow. Orr later provided the FBI with all of his wife's opposition research, paid for by the DNC and Clinton campaign via Fusion GPS. The Orr's relationship with Steele and Fusion GPS was inexplicably concealed from the FISA court. Number 4. According to the head of the FBI's Counterintelligence Division, Assistant Director Bill Priestap, a corroboration of the Steele dossier was in its infancy at the time of the initial Page FISA application. After Steele was terminated, a source validation report conducted by an independent unit within FBI assessed Steele's reporting as only minimally corroborated. Yet, in early January 2017, Director Comey briefed President-elect Trump on a summary of the Steele dossier, even though it was, according to his June 27 testimony, quote, salacious and unverified, end quote. While the FISA application relied on Steele's past record of credible reporting on other unrelated matters, it ignored or concealed his anti-Trump financial and ideology motivations. And we all wonder, why the hell would he conceal that? It's Keystone Cops. Furthermore, Deputy Director McCabe testified before the committee in December 2017 that no surveillance warrant would have been sought from the FISA court without the Steele dossier information. Oh, we're covering 5 points. My mistake. Here's number 5. The Page FISA application also mentions information regarding fellow Trump campaign advisor George Papadopoulos, but there is no evidence of any cooperation or conspiracy between Page and Papadopoulos. The Papadopoulos information triggered the opening of an FBI counterintelligence investigation in late July 2016 by FBI agent Peter Strzok. Strzok was reassigned by the Special Counsel's Office to FBI Human Resources for improper text messages with his mistress, FBI attorney Lisa Page. She's no known relation to Carter Page, where they both demonstrated a clear bias against Trump and in favor of Clinton, whom Strzok had also investigated. The Strzok-Lisa Page text also reflect extensive discussions about the investigation, orchestrating leaks to the media, and include a meeting with Deputy Director McCabe to discuss an, quote, insurance, end quote, policy against President Trump's election. End of the House memo on FISA abuse. You remember the punchline. Comey is going to, he's leaving Congress and he's going to the Department of Justice, just sharpen the guillotine. And felony. Now, whose constitutional rights were conspired against? The privacy right of the subjects of the FISA warrants. They had rights against those warrants under laws of the United States, the FISA law. The evidence was not credible, and relevant facts about the evidence were not disclosed to the court. Callers had statutory rights under FISA that were conspired against. Is that a felony? 18 U.S.C. 241. Conspiracy against constitutional rights or rights secured by statute. How is it not a felony? The next one, the right of Mr. Trump to run and become president was conspired against. Is that a constitutional right? In the purest sense, right to redress. I'm going to run for office. Yeah. I say it's a constitutional right. The majority of voters had the constitutional right to have their elected commander-in-chief, but this memo proves that to be the target of these actors. They were conspiring to keep the elected official, Donald Trump, out of office. How did they not commit a conspiracy against the rights of one or more of these three parties, these three entities, these three interests? So has there been a felony committed? And if so, who committed it? Are your suspicions reasonable? Here's a list of federal criminal statutes. 18 U.S.C. 2. Whoever operates a particular criminal enterprise can be charged as a principal. Accessory after the fact. 18 U.S.C. 3. I think these are in the citizen's arrest video here on my YouTube channel. 18 U.S.C. 4. If you know of a felony and take steps to cover it up, you're guilty of a felony. You better report it. 18 U.S.C. 241, conspiracy against rights. That's our topic tonight. Did any of those people commit this felony? It's the easiest one. They live here. This is their home address. 18 U.S.C. 241. You can ring this bell all day long. If you just learn criminal pleading, code pleading, learn what statute says, and I'm talking to the individuals that think they know something and they're in the patriot movement. They got no political power whatsoever. You have the right to arrest a felon. Why the hell wouldn't you want to identify a felon? Get to the point. Stop cowering in your caves going, I'm sui juris. Engage government. This is how you do it. Code pleading. 242, deprivation of rights under color of law. On Hannity today, Greg Jarrett, Fox News contributor says 242, deprivation of rights, it's a felony, 10 years. No, it's 1 year. And so he mixed up 241, which is 10 years, conspiracy against rights. So he read 241. He still hasn't hit the button yet, though. He hasn't put it together. They're almost on it. 241. That's the one. And then everyone in America can arrest him. It's just waiting. Extortion, not in this case. Mailing, threatening communications, not in this case. But I suggest you read those statutes. Read a bunch of appellate case law about those statutes. 880, receiving proceeds of extortion, no. Kidnapping, no. Frauds and swindles, this is through the mail. Did they try to get somebody's money through the mail or an advantage or a property right by fraudulent pretense? This is doing it by the internet or by the phone or by wire transfer. Fraud by wire, radio, or television. 1621, perjury. They have an oath of office, I presume. And then if they break the laws of the United States, how come that wouldn't be perjury of their oath? It's a standing oath. It doesn't just count the day they take office. And so what's the penalty here? In any declaration, let's see, the second one, 5 years or both. Yeah, 5 years or both. Okay, yeah, that's a felony. Perjury, if they violate laws of the United States, even a misdemeanor, it's perjury of their oath. That brings it to a felony, doesn't it? Thank you. False declarations before a grand jury or court. They just might have gotten this one a couple times in this operation. Not more than 5 years. Okay, felony. And I haven't heard these mentioned, and I listen a lot. Jay Sekulow, Sean Hannity, his guests, Brett Baer and his guests, his reporter Catherine Herridge, very astute lawyers like Shannon Bream, Laura Ingram. Nobody's hit on these, and not this one. Interference with commerce by threats or violence, kind of like when you're out in the street throwing rockets and breaking the front windows of grocery stores and banks and blocking the street, praying. Interfering with commerce by threats or violence. Yeah, you occupied the street. That's unlawful imprisonment. That's violent. Prohibited activities, that's RICO. 18 U.S.C. 1962. Search warrant procured maliciously. I went through these before I put together these ideas for this presentation. And I said, I haven't mentioned that one in a long time. 2235, whoever maliciously and without probable cause, that means it has to be probable cause in the court you go to. The FISA court has heightened standards of probable cause. Procures a search warrant to be issued and executed, shall be fined in this title and prison not more than 1 year. Let's throw that on the fire. Okay? That's a no-brainer. Now, and we're coming to another punchline. You're going to like this. I'm sincere. You will like this. Now, rebellion or insurrection, the deep state. A bunch of people, holdovers from the last administration, think they should just turn this knob the wrong direction and flip this lever the wrong way, turn this switch off, remove that fuse, and leave that door open. And they're just sabotaging everything right and left. The more you listen to the people in the know, you just find out that, yeah, there's an effort by holdovers to and they got a couple in this sting right here. These FISA memo or this FISA court warrant sting here. A couple of them got had. They wanted Hillary, and they were doing anything they could to make sure that she won. And they all presumed she was going to win, and that made them act carelessly, and they got exposed. rebellion or insurrection, 18 U.S.C. 2383. Whoever incites, that means encourages, whoever incites, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, like the elected commander-in-chief, or gives aid to the people that are doing it, shall be fined under this title or imprisoned not more than 10 years or both, and shall be incapable of holding any public office under the United States. Thank you. They could always become a governor of a blue state. 18 U.S.C. 2384, seditious conspiracy. If two or more persons in any state or territory in any place subject to the jurisdiction of the U.S. conspire to overthrow, put down, or to destroy by force, not conspire to overthrow by force, put down by force, it's just to destroy by force. Well, let me see. Maybe there'd have to be a comma after the word force. Conspire to overthrow by force, put down by force, or destroy by force. Depends on the court you go to. If the Ninth Circuit wants to go the government's direction, that's the way it's going to go. Right there, if there's supposed to be a comma in the mind of some appellate judge after the word destroy for by force to apply to the phrases before it, okay, that'll be parsed right there. The government attorneys will parse the hell out of that in favor of the side that they want to win. Anyway, conspire to overthrow? Sure. Conspire to put down? Yeah. Conspire to destroy by force? Not yet. The government of the United States, or to levy war against them, or to oppose by force the authority thereof, or to prevent or hinder or delay the execution of any laws of the United States. Okay, we just rang the bell. Or by force, that means what came before it. By force doesn't apply to it. To prevent, or by force to prevent or hinder or delay the execution of. Came from behind. By force to seize, take, or possess any property. You have to watch for the element of force. It sounds like in all of that. And then 2385, advocating the overthrow of the government. Whoever knowingly or willfully advocates, abets, whoever knowingly abets or teaches the duty, necessity, or desirability or propriety of overthrowing or destroying the government of the United States. Didn't say by force. Did it? Whoever advocates, abets, advises, or teaches the duty, necessity, desirability, or propriety of overthrowing or destroying the government of the United States. Socialism. Whoever with intent to cause the overthrow or destruction of any such government prints, publishes, edits, issues, blah, blah, blah. These are particulars that just will not apply, so I'm going to skip them. Whoever organizes or helps or attempts to organize any society, group, or assembly of persons who teach, advocate, or encourage the overthrow or destruction of any government by force or violence. You have to be honest, be better than our prosecutors. You have to meet every element of an offense to be guilty. And if they don't meet a particular offense, skip it. Be better than them. Shall be fined under this title or imprisoned not more than 20 years. Felony. We're trying to ring the felony bell in all this. Who can we arrest and why, and what time would be most inconvenient. Now, the deep state. Gosh, how are we going to get this many indictments? How are we going to perform this many grand jury investigations? I saw one stray article, meaning not from a major source, that said they believe there's over like 1,800 sealed indictments, which would explain, which would be another good reason, perhaps, why Gowdy would leave the Congress and go back to the DOJ. But you don't have to have a grand jury investigation to get somebody into a plea agreement. They can plead guilty to a criminal complaint. A criminal complaint can be signed and filed by an FBI agent, a Department of Homeland Security agent, an ATF agent. I've read them. And a person can be confronted with that and plead guilty. Isn't that simple? They didn't go to a grand jury. There's no leaked information about the grand jury or about who might be investigated by the grand jury, or who the special counsel was appointed to investigate. Very simple. We have this, and this against you. We think you're guilty of this. And we wrote this criminal complaint. You ready to plead guilty to this, or do we have to get an indictment? That's a pretty good question. I bet you get a lot of plea agreements that way. You can get a lot more than that. How to drain the deep state stronghold. First, establish reasonable suspicion that felony violations have been committed. Reasonable suspicion, not probable cause. 2, approach the perpetrator, with a contract of resignation, because it's hard to fire these people. And once they lawyer up, it's like pulling teeth to get them off the payroll. They'll be collecting a paycheck for years and years, and just weigh down the justice system with a bunch of litigation that where they have to defend the firing. So you approach them with a contract of resignation, because if they don't sign it, they'll be arrested in front of the media that's waiting outside by an employee of the Department of Justice who has the reasonable suspicion to believe this person's committed a felony violation of the law. A reasonable suspicion, not probable cause. You'll find among that case law on citizen's arrest, hey, I was arrested by an officer and we were outside of his jurisdiction, and so he shouldn't have made the arrest, and I'm suing for false arrest. And the court ruled, well, while he was outside of his jurisdiction, he didn't cease to be a citizen who had reasonable suspicion to believe you committed a felony, and so as a citizen he had every right to make the arrest. So as a DOJ employee, I could say, I got reasonable suspicion this person committed this felony, and therefore I have the right to arrest him. And I walk up to this perpetrator with Jeff Sessions standing beside me, or his deputy, whatever, and they tell the guy, you can sign this contract of resignation and we won't arrest you in front of the media waiting outside. But they're there to ask you, if you walk outside without your handcuffs, why you resigned. And if you walk out and are handcuffed, they'll be asking, any comment? And you'll be saying, no comment. Which one do you want? And bingo, that actor is gone because of reasonable suspicion to believe a felony has been committed, and the right of the individual to arrest that felon. Number 3, perhaps prepare and show a criminal complaint yet to be signed. Final draft criminal complaint with no signatures on it yet. It hasn't been to a court, and a signature for resignation. If you don't resign, we'll go get this criminal complaint signed and present it to a judge. Are you going to regret having not resigned then? And there's no grand jury. You don't have to convene a grand jury, present evidence, get an indictment. You just develop reasonable suspicion, and you get to the next statement here in quotes. We simply can't have an employee walking around, one that America relies upon, who can be cuffed and taken off the job by anyone in the country anytime they want. You understand? Do you see any exceptions in the case law to citizen's arrest of a felon by one with reasonable suspicion? Anybody that has reasonable suspicion, on or off the job, common law right. And in none of that case law did they say, oh, unless it's a public servant, you can't arrest them. Nowhere. And so simply by intimidation legitimate intimidation, a valid exercise of force. I have the right to arrest you. You want to be arrested in front of the media outside, or do you want to quit? Bingo. That's justice the cheap way. And just because you're quitting and you signed this contract, co-worker breath, don't think that you're not going to be indicted. This is not a waiver of the United States right to bring criminal charges against you. So don't leave town. They can't force you. That takes a court order. But we have reasonable suspicion you're going to be arrested. We can't have you walking around the office when everybody here can arrest you. You know, we gotta put everybody's rights on hold because you got a job? I don't think so. Flake off. You're out of here. Clean out your desk. This is Officer so-and-so. He'll watch you to make sure you don't take any company property. Can you hear how quickly I could clear somebody out? We have reasonable suspicion. You want to be arrested or do you want to quit? Arrested on camera. Today's political climate, you don't want to be arrested on camera. It's a rule. Because the internet's forever type stuff. Anyway, this has been my review and unique and pointed or focused extrapolation into citizens' arrest on keep your eyes open. They could accidentally violate that statute that says don't conspire against rights, 10 years in prison. They do it all the time. And Trey Gowdy, he's going back into the Justice Department. And you're going to see at least a flood of indictments. I'll bet you he's gotten into this far enough to say, this is BS. It took us a year to get this information, and look what it reveals. You put me in the Justice Department, and you can let Jeff Sessions call the shots, but you just give me a whip, put me in the Justice Department, and I'll organize a front. You bet. So I don't think it's to assume the role of Department of Justice. Or, Attorney General. I think it's to take on the role of special prosecutor assigned to a very particular case, because I'll bet you they sense, I've heard that this is just 1/10 of what's going to happen regarding this FISA warrant and Russian dossier. And it just might be important enough to get the people they believe now that they could get with felony violations of the law. It might be valuable enough to Trump and, of course, to America, because he wants this to happen for America. If this is the reason, he wants everybody to see the people responsible go to prison. So Trey Gowdy, I don't think will be Attorney General. I think he's going to play a role under that, specifically directed at getting indictments and convictions against the highest people involved in this, the ones that probably conspired against Bernie Sanders, against Donald Trump. They know more than what's in this memo. They probably have enough to where Trump and Gowdy had a beer or a round of golf, and agree that, yeah, we want you back in the Department of Justice, full latitude, and go put some heads on poles. So I think that's what's going to happen with Gowdy leaving Congress. My name is David Myrland. Thanks for taking the time out to join me with another Codebreaker presentation. Enjoy the rest of the videos here on my YouTube channel, wevgov.com. wevgov.com is my website. Easy to read. And inexpensive materials available on thebookpatch.com. thebookpatch.com. Search their bookstore. Author's name, Myrland, M-Y-R-L-A-N-D. M-Y-R-L-A-N-D. And there's my publications. I appreciate your support in advance. Thank you very much. And I'll see you on the next episode.